23. Restriction on finding of non-maintenance. A finding in accordance with section 16 sub 1G of this sub 1F of this act shall not be made unless the court is satisfied that reasonable attempts have been made by the petitioner to enforce the order or agreement under which maintenance was ordered or agreed to be paid. Section 16(1)(f) provides that the respondent has habitually and willfully failed throughout the period of 2 years immediately preceding the date of the petition to pay maintenance for the petition. So this is maintenance. So it says that a finding in accordance with that section for maintenance shall not be made unless the court is satisfied that reasonable attempts have been made by the petitioner to enforce the order or agreement under which maintenance was ordered or agreed to be paid. Yes.
I think it's self-explanatory. I think we understand.
We all understand.
I don't understand. Please explain it.
Okay, I think it's self-explanatory that before the court will only hear such a petition to enforce that the right to payment of that whatever it is in section 16(1)(f), only if the petitioner would have enforced the right to receive those payment as it has under the agreement.
As enforced.
Made effort.
He has made effort to enforce it first.
Mm.
But if he has not made any effort at all, the court will not hear him.
The court will not consider it as the court will not consider making any further order to that effect if there was no effort to follow up on the agreement or whatever was ordered. 24. Restriction on finding of insanity. A finding in accordance with section 16 sub 1G of this act shall not be made unless the court is satisfied that at the commencement of the hearing of the petition, the respondent was still confined in an institution referred to in the said section 16(1)(g) and was unlikely to recover. In an institution.
Longer period.
Yes, Josh.
From what this section is saying, before the courts can find for insanity, the petitioner must prove that the respondent was insane before the commencement of the petition, before the court can grant whatever it was to grant.
Is it just that he was insane?
Before the commencement of.
Is it just that he was insane? I don't think so.
It's neutral. That's what this place is talking about.
And he has also been confined to a place.
Before the commencement of the
He has also been confined to a place.
like
And there's already a likelihood of him not recovering.
I think the one important point there is the confinement. The confinement in an institution.
like in the psychiatric room.
I think even with our courts, you cannot establish insanity by mere hearsay. But I say hearsay by mere oral evidence. You must give evidence to establish insanity, especially something that relates to being confined in an institution because of your insanity. You know, the institutions that cater for. You want to check?
Check me.
What one? Which one?
No, yeah.
So the G, what the G says, section 16 sub 1G says that the respondent is at the time of the petition of unsound mind and unlikely to recover. It also says that since the marriage and within the period of 6 years immediately preceding the date of the petition, he has been confined for a period for periods aggregating not less than 5 years in an institution where persons may be confined for unsoundness of mind, in accordance with law. So this one now is saying that for the purpose of that section, that at the commencement of the hearing, that a finding of insanity will not be made unless the court is satisfied that at the commencement of the hearing of the petition, the respondent was still confined in an institution referred to in the said section 16(1)(g) and was unlikely to recover. So meaning at the commencement of the hearing, he should still be in that institution sef. At the commencement of the hearing, the person that is insane should still be confined. You cannot be out and you are establishing insanity. You should still be confined in that institution. But is this not a section that should be amended? Because insanity is in grade levels. There is a grade level of insanity that is likely temporary.
Yes.
There is occasional insanity. There are insanities that are induced by events. So something occurred and there's a negative expression that is marked for insanity. It is not like the overall insanity where the person is naked and talking rudely all the time. So what happens for that level of insanity? Because that level of insanity can also make the marriage
endanger the spouse.
And make it unreasonable for the petitioner to continue in the marriage. Because if something spontaneously happens, the person behaves like this, then he does not behave like that for another 1 month.
But that will now be under the category of conduct that you are not expected to live with.
And it's those conducts that section 16 have elaborated on, and the G now says particulars of insanity. I says is at the date of the petition of unsound mind and unlikely to recover. Then the II now says that since the marriage, I think there are two options, because the unsound mind is different from the second one. One says is at the date of the petition of unsound mind and unlikely to recover, and since the marriage and within the period of 6 years immediately preceding the date of the petition has been confined for a period of. So the first one can be unsound mind that is not confined. Do we think so? Let's look at it.
Then the second one
Is insanity that you are already confined. So one is first grade level, second one is second grade level insanity. Can we say so?
Maybe after once the thing triggers, the person is now breaking things in the house. There is evidence of those things that are broken in the house. I think that should be a ground. Don't expect to live with somebody that breaks things in the house. Maybe there's something that triggers in him once in a month or once in 2 months. You know, people have repeatedly bought television.
Although I would want to
Pray for the person.
No. Take another. I would want to differ actually, because when two persons are coming to, they are coming together to cohabit or to whatever. No, not to cohabit, to marry. It is for better, for worse. And in my view, I would want to consider that.
The prayer.
Is it in the law? Is it for better, for worse in the law?
For better, for worse.
In the law? In the law?
That is their marriage vow.
In courts?
No.
We are under the act.
No, under the act.
The research is under the act, not under the church.
Or the spirits.
Or the spirit. So for better, for worse, is it under the act?
For them, no, my point now is that.
Because if it's for better, for worse, this unsound mind, you should not even leave the person. Because for better, for worse, in unsoundness of mind, madness, you should continue.
I think the law is more like, from that provision, it is clear that there is no longer hope for the marriage to continue. So it stands dissolved. But when the insanity comes occasionally, it qualifies as an illness, which should ordinarily be cured.
Which falls under the category for worse.
So it should not be it should not be a ground to dissolve the marriage.
So it should be, that means you are saying that the extreme case, which is being in the institution of insanity,
no hope of recovery,
where you are confined, is only that one.
Yes.
Please, let's go back and read section 16 sub 1.
You have brought your pastoral.
No, there's no. No, let's just understand what the law says. So it says the respondent. Remember, we are saying that without prejudice to the generality of section 15 sub 2 of this act, the court hearing a petition for a decree of dissolution of marriage shall hold the petitioner has satisfied the court of the facts mentioned in the said section 15 sub 2c of this act, if the petitioner satisfied the court that g the respondent is at the date of the petition of unsound mind and unlikely to recover. Of unsound mind and unlikely to recover. And this and does it mean that the I cannot go without the I?
That they work
They are
together.
together.
They are together, abi? And since the marriage and within the period of 6 years immediately preceding the date of the petition has been confined for a period of or for periods aggregating not less than 5 years in an institution where the person may be confined for unsoundness of mind in accordance with law or in more than one of such institutions. The and now is my problem. If the and joins the two as a conjoined twins, it means that the unsoundness is in the extreme, like he is saying.
The thing is the I
Move your check
I
for the mic.
starts on its own. Because what the I said that since the date of the petition of the assignment and it's like unlikely to recover. Unlikely to recover is not what anybody can ascertain. Why the I is saying for a period of more than 5 years, this person has been confined in a psychiatric home to actually show that see the reason for the grant for the divorce. This person is insane. Now he has been there for a period of more than 5 years. So the two sections, the first one is just the insanity. Why the I explain the circumstances at which of the insanity.
So they are together.
They are together.
They are together at
So
which.
what this man said is correct.
So the both of them are
So
together.
that means there needs to be an
But he brought
amendment
it-
of this
He
law.
brought it to a pastoral way.
He brought it by the better for worse,
Eh.
which I don't know whether better for
There's no
worse is
better for worse
recognized
in
in our law. Because if better for worse is recognized in our law, the imprisonment should not be a ground. Because imprisonment, you are convicted and sentenced.
And if it's better for
And if-
sanity should
and
not the ground.
because if the imprisonment and the imprisonment, I think the term of years that was
It's
there
just 3 years.
Whereas people used to go abroad, they will leave
5
their
years.
wife 5 years
And
so
come back.
lost contact.
and they come back because they are abroad. Oh, the woman waits.
So this is just to say that the law is not for better for worse.
The law is not for better for us.
Jeremiah, is that one okay?
Better for
The
us.
law does not accommodate
It's
better for
it's
worse.
for good and a little worse.
I think it's actually it's accurate actually. Whether the law supports better for worse or not.
Maybe you
Marriage
use
act
AI.
this section.
You use that your AI to check let
When
us
the
know
marriage
the
is
origin
broken
of
down
for
into
better for
people.
worse, because that for better for worse is a problem
In this issue.
in society. It's
There's
a
no
very
better
serious
because
problem.
under
Because
the
all
marriage
the ones
is
we
more
are
like
seeing
a
is for
contract.
better. Oh. All the worst doesn't
if
work.
we look at the grounds, almost all the grounds via which the law terminates the contract of marriage. There are grounds that shows that there is no way for the marriage to continue. For example, this insanity.
Imprisonment in court.
But imprisonment is just 3 years now.
Adoption is just 3 years.
For 5 years.
No, 3 years. Even 5
It
years.
says, it says for not less than 5 years.
No, imprisonment is
This one is confinement now for the unsound mind. That is it.
unsound mind is 5 years.
Yes.
Imprisonment is
It's
3
3
years.
years.
Okay, I
That
was
is
speaking of
sub F.
insanity.
Mhm.
Insanity. I do not see the only difference between an insane person and a dead person is that he breathes and he functions like a human being. But apart from that, he cannot carry out his conjugal.
Are you sure the same person is not more active in bed than the somebody that is not?
Those who don't see the mad women, they are
Mad
pregnant.
women, the mad men are more active. Mad men, I have even noticed that mad men's reproductive organ by default is
It's
on
very
an expanded
massive.
scale.
But I feel this section is subject to review because you are saying confined in an institution for 5 years. So
years.
for 5 years, what will the other
What would
party
the other person be doing?
So
That's where
that's
the review is
the
supposed to come.
No, that one is even on another scale of
Scale,
review. Maybe to reduce the time to
The
5
5
years.
years is a long
But
time.
me, I'm even saying that what about temporal insanity? there is
comes and
insanity
goes.
that is not perpetual. That kind of insanity, they might not take you to the institution and keep you.
You can live with that one now.
The section, that
You
is
manage
why-
that one. What if one of the days it comes up now?
Comes
Then
off na
No,
death,
see the section. Now the section made it clear that at the date of the petition of the unsigned man and unlikely to recover. You see that statement, unlikely to recover. Insanity that was
that your
triggered
own
by
that is
circumstances.
partial.
Partial.
recovery.
No, you are
How you
recovering.
recover?
No, that one is more difficult to recover.
Partial that they cannot check
They
how
even
the thing
live.
come.
They even live with that thing.
No, see, insanity that is triggered by occurrence of an issue or circumstances is likely to recover. You walk into a house and you saw your wife with another man. At that minute, you are insane.
No, that one is not insane.
That was not
one is heat of passion.
Heat of passion.
We are
Now,
talking about
eh,
there is a matter we did now recently that has something similar to this insanity. It's a murder trial. It is established that it pops up. There was an occasion the person fell and got a damage on his brain. But it's not perpetual.
that one can be managed.
It's a temporal psychosis. There's the terms the doctor used.
Which can be managed now.
And no, the management now
Is the
is
problem
that
now? If
the thing pops up by an event. You can see something and it pops up. If you see something that makes you remember the death of his father, it can pop up.
An example,
If he sees an anger issue, it can pop up.
a bipolar patient.
and then the response to
It's
that thing
spontaneous.
is your death.
Now, a bipolar patient, the society even allows them to marry and live with children.
Who is bipolar? Sorry.
A bipolar is somebody, it's a level of insanity.
Okay.
It will be triggered, it will just come. And at that point, when it comes, he will not know if this one is his child or his wife. At that point, though,
Yes,
Then if the person is holding a knife,
he can kill you at that point.
you will marry bipolar.
So, but
Knowing for marrying the bipolar.
as far as so
No, we are trying to get
why will
this
I
thing.
be that is already
Why
married?
you are encouraging the bipolar? Why are you encouraging the bipolar? We are telling you.
Well, that's
We are
it's the
telling
law
you.
now, so we have to
But I
accommodate
really
everybody.
think that because we are also considering suggested
But if I
amendments,
marry
I think that one of our suggested amendments should be a consideration of a level of insanity that is not in the extreme. What should be the consideration? There should be a reasonable consideration for that.
Then there will not be like a kind of there can be separation. You understand?
Yes.
Something like separation.
a directive for separation until that
come and go,
temporary
come and go.
insanity is confirmed either as main insanity or is
Yes, because
you cannot stay
you
under
cannot
the
come and
risk
stay under the risk of
the
bipolar.
temporary-
No, like as a bipolar, I've seen situations where maybe they were not taking the drugs, they triggered, and they had to go for these insanity homes for some times for them to help you to manage until when they certify that okay, at this point this so person can, because the situation was he tried to kill his wife because he was not taking his medications, so the thing came.
the medication is for the insanity.
Had to like suppress.
You see? So it's suppressing an insanity that you should have been in the institution.
You see? So he has a family.
Ordinarily, you don't want to be in this situation.
So he has a family. So if a paraventure commits murder in that state, insanity flies.
As a defense.
Yeah, as a defense.
Meanwhile, the dead is gone.
Yes. So
I think marriage, oh.
I think-
what
I
we're
think-
discussing now is marriage, oh.
and
that you cannot really leave.
and there are so many bipolars that are married, for unfortunately. So many of them are married. So I think the section is vague entirely.
Yeah,
So
there needs to be an
it
amendment.
need to be amended and let's know the level of insanity.
All the
Because